Hi, welcome to Compliance Talk. I'm Michele Shuster here with my colleague Chad Blackham, and we have some breaking news here for you this week as always. First, and mostly just because it's baseball season, there's an interesting case that's going out there that involves the Boston Red Sox. Love them or hate them, it doesn't matter. They have an interesting case that's going on, and it's interesting for two reasons. One, because the basis for the lawsuit is suing the Red Sox franchise for deceptively advertising the cost of their tickets. As you know from listening to these talks, that the states all have their own consumer protection laws. Generally, we call them UDAP laws, Unfair Deceptive Acts and Practices laws. And here the issue was that the Red Sox were advertising one price and then tacking on additional what they called junk fees that were sometimes as high as 150% of the ticket price. So consumers brought a lawsuit against the Red Sox, and what's interesting right now about that case is there is a motion pending to arbitrate that case. And the issue is that was that arbitration disclosure clear and conspicuous as the Red Sox fans were going online to purchase tickets? You've probably heard us talk about this a couple of other times on these episodes, but when you're including an arbitration clause into your terms and conditions, and consumers are going through websites, it's really important that you disclose that on the website, that there's an arbitration provision that will apply. That can't be buried. Here the issue with the disclosure was it was a gray font disclosure on top of a white background. So it made it not so clear and conspicuous for the consumers to see that there was an arbitration clause that would apply. So interesting news on that front. The two takeaways there are, if you have additional fees other than those that are advertised directly to the consumer, make sure you're disclosing those clearly and conspicuously before the consumer goes to purchase that product. And then also, just to make sure that your arbitration clauses are clear and conspicuous, I would encourage everybody to have their arbitration disclosures and clauses reviewed by legal counsel. It's not an extremely time-consuming thing, and definitely worth the ability to exercise that arbitration clause if it becomes an issue. The other one, this one is just so ironic to me. And the reason this one is ironic is it has to do with the Reassigned Number Database. And years ago, we met with the FCC around the creation of the Reassigned Number Database, and they were adamant that this was always going to be a safe harbor provision and not a mandatory requirement. And as you probably know, what the Reassigned Number Database does is it allows you to query the calls you're about to make, or more specifically, the phone numbers for the calls you're about to make, that you have consent to place that telephone call to make sure that it hasn't been reassigned to a new subscriber. Obviously, the issue there is if you have consent to place the telephone call, but not from the new subscriber, then you don't have consent at all to make that call. And so what's happening now is, as you probably also know, Maine currently requires that before you make calls that require consent into the Maine jurisdictions, that you scrub against the Reassigned Number Database, therefore making it mandatory. Well, another state that starts with an M is following on Maine's footsteps, and that's Missouri. They have introduced in their General Assembly a bill that would make Reassigned Number Database scrubbing mandatory. It's passed the House, it's moved over to the Senate, and obviously we'll continue to monitor this should it be passed by the Senate and sent to the governor for signature. So with that, what do you got today, Chad?
Absolutely, Michele, thank you very much for that. So we have some other developments in the TCPA world for me, as well as some interesting AI developments I'm going to recap. But first off, an important case coming out of the District of Delaware entitled King v. Bond charge. And what's interesting about this case is it reflects a continuing trend we see in the TCPA litigation space, which is as we see the limiting of the definition of an auto dialer post Facebook v. Duguid and other limitations, we're seeing more creative avenues for lawsuits to be brought. This one involving a lawsuit against the TCPA's quiet hours restrictions. So as many of you likely know, the TCPA and its promulgating regulations limit the times under which you may call an individual from 8 a.m. to 9 p.m. local time. Now, what was at issue in the King case was whether the requirement that you obtain the consumer's consent also extends to a separate consent requirement to call outside of these designated hours. And what happened here was the consumer received a text message opted in for more, and then received some outside the designated hours. Well, thankfully for all the businesses out there, the court held in the negative and said that a separate consent requirement was not required in this particular instance. The court held that the voluntary provision of the individual's number was sufficient for prior express consent and allowed them to be called outside of the regular calling hours. Now, the reason this came up is because, as you also may be aware, the DNC promulgating regulations of the TCPA and the TSR require a signed agreement by the consumer. This case is important because it holds that a signed agreement is not necessarily required for these quiet hour restrictions. The consumer's voluntary provision of that phone number is generally enough. Now, I will caution this is limited to the district in which it occurred, but we may see this extrapolated to other jurisdictions in the coming months, particularly since I think it is a well-sounded ruling and makes sense from a logical perspective to me. So for those of you out there calling outside the regular calling hours, particularly within this jurisdiction, prior express consent, the consumer's provision of their phone number, is generally and likely going to be enough for those purposes. So that's good for all the businesses out there. Now, turning to some potentially more impactful considerations that may not be as positive, we have a few developments in the AI space. The first of which is something we've talked a little bit about before in Compliance Talk, which is Alabama's law. Alabama's law has been passed, and it will be going into effect. Now, Alabama's law regarding data protection is very similar to other states, but what is really important here, it has the absolute lowest threshold of any privacy law in the United States at this point. 25,000 people is all it takes for you to be eligible for coverage under the Act. So if you're collecting PI, personal information, servicing Alabama residents, definitely make sure to consult legal counsel and see if this applies to you. Second, we also have Maine. Maine, fortunately or unfortunately, depending on your perspective, did not end up enacting their privacy law. It did not end up getting signed by the governor, and so theirs is not going into effect. Kentucky, conversely, has expanded their AI data protection privacy law, particularly the definition of sensitive data, to include automated decisions from smart technology. So if you're collecting data from a smart TV or a smartwatch or anything like that, that may be included within the definition of personal data. So if you're working in Kentucky, if you're buying personal information from vendors in particular, I think it's really important to do some due diligence and determine where they're getting that information from, because under this new definition, it may qualify as sensitive personal information. And finally, we have an update from Maryland, who is implementing a new pricing law for grocery stores, limiting the use of individual customer demographics to create what is very charitably referred to as comparative pricing, which is a fancy way of saying they will change the price based on your viewing habits and shopping behavior. This is now required to be disclosed to consumers, and the circumstances in which it can be used are now limited. And finally, I want to touch on a development in a case we had during our last compliance talk regarding Colorado's AI Act. So for those of you who took the opportunity to watch, Colorado is in the process of implementing its new AI Act and had been challenged by the federal government. This is particularly notable because Colorado had the most strenuous AI Act out of any of the states by my measure, and also because it was the first test of the federal government's stated policy to exert federal supremacy over state AI laws, if you recall from a couple weeks back as well. Well, it looks like Colorado has now suspended enforcement of the act. The case is no longer moving forward. Everything is kind of halted for the time being. But the federal government's actions have proven to be fruitful, and Colorado, as I mentioned, has currently suspended enforcement of the act and is not currently scheduled to go forward. So lots of developments in the AI space, particularly with those really strenuous laws.
Well, great. Thanks for the update. We'll see everybody on the next Compliance Talk.